Welcome to Floyd Zadkovich's video series. I'm coming to you from London. I'm here for London International Shipping Week 2017. It's a big week for UK shipping and actually a mainstay on the international shipping calendar. It's a good week to be here. There's a lot happening, a lot of people in town. Great to see old friends and colleagues. And I think there are 100 events, presentations, road shows. There's even a black tie dinner on Thursday night, which I'm very much looking forward to. And this is the end of day one. So I went to a number of events today, and I thought that for those of you who aren't in London or couldn't make it over for whatever reason, you may appreciate getting a bit of a flavour for what people are talking about. What are the hot issues? Especially in the legal field. So the first event that I went to this morning was an event put on by Quadrant Chambers. They are a leading set of barristers in the shipping space, and three of their barristers gave presentations this morning, fascinating presentations. John Russell QC, Nichola Warrender, and Rob Thomas QC. Simon Rainey chaired the presentations and created some lively debate thereafter. Now, I think the key takeaway from that event was just when you think you know everything about a particular topic, along comes a case, or in this case, three cases, which challenges that thinking and makes you think, well, maybe I didn't really understand it as well as I thought I had, or the court's changing the understanding slightly. And for all of us who are involved in handling cargo claims, I think it's fair to say that we're all aware of the burden of proof game of ping pong, as it's politely or affectionately referred to, and the Court of Appeal in the recent case of the Vol Cafe dealt with this particular issue, and it's also on for appeal and going to the Supreme Court, due to be heard in the back half of 2018. So we could well be hearing about this again. Now, John Russell QC dealt with the issue very clearly, and I think that the key aspect of this decision was, well, we know that cargo has to hit the ball first. It serves and sends the ball over by establishing damage to the cargo. The carrier then hits the ball back by establishing that an exception applies. Now, it's really on the way that the carrier or how the carrier can hit the ball back to cargo that this decision was focused on. And the Court of Appeal, it found that the carrier only has to establish a prima facie case that an exception to an exception applies. So in the Vol Cafe case, the carrier could show a prima facie case of inherent vice in the cargo. Now, that was enough to hit the ball back to cargo's court. They did not have to establish the entire case that it was an inherent vice. It's just a prima facie case. And then the burden shifts to cargo, according to the Court of Appeal, to then prove negligence by the carrier, which will then negative the operation of the inherent vice exception. So that's going to be interesting to get a Supreme Court decision on the burden of proof in cargo claims, and to continue to show that shipping law keeps us on our toes, and there are now, or just recently, two first instant cases on the package limitation, an area that has had a lot of decisions on it, let's just say, and one that we probably thought was close to being resolved. But anyway, there have been two recent decisions, the Aquasia and the Maersk Tangier case, two separate cases. And barrister Nichola Warrender dealt with two of the key issues in those cases. When are the Hague-Visby rules compulsorily applicable? First issue. And secondly, what is a unit? Now, on the first issue, the court decided that for the purposes of whether UK COGSA applied, the determining factor was did the contract provide for a bill of lading rather than the parties' use of a waybill. In that case, the parties used a waybill. The question was, did that change the nature of the contract and the applicability of the Hague-Visby rules in the absence of a bill of lading actually being used? Nichola also identified a difference between US law and English law on the meaning of a unit. Now, at our firm, we're always interested in identifying differences between US and English law, as we advise on both bodies of law. So it's particularly interesting for us. Anyway, the US COGSA, which is the US equivalent of the Hague-Visby rules, refers to the package limitation as applying per package or customary freight unit. So a bulk cargo measured by metric tons under US law will be a customary freight unit, whereas in England the term unit means physical unit for shipment. It does not mean a customary freight unit, as is the case in the United States. So unit as a term under English law could not therefore apply to bulk cargo. The third presentation was by Rob Thomas, and Rob gave a detailed analysis of why Mr. Justice Baker in this decision preferred not to follow the Australian Federal Court case of the El Greco, which has had a lot of interest in shipping circles. And the judge limited the Australian case to its facts and really said that it was a case that dealt with misenumeration or misdescription of the cargo. And the judge found that the bill of lading or waybill must state that the number of what was in fact the unit of cargo as packed, and nothing more is required. That is, it is not necessary to state how the cargo is packed. And so that was a very interesting talk as well. I'll move on to the next topics in the next video.